guys, it's Kathy. I hope you're doing well. We made it to Tuesday and the end. Ugh, Jesus. We made it to the last day of OJ. We have been at this for so long together. If you made it this far, if you were with me for like 80% or more of this trial, type something in comments. Even if it's 3 years later. If you made it through 80%, like no one can make it through every single OJ video. No one can. If you did, if you watched 100% of every video, you make sure that you definitely type that in chat. Not in chat, in comments. But if you even made it to 80%, put a comment in. I want to know. I want to know who's been like just doing this since the beginning, banging our heads against the desk since the beginning. So many things happened I didn't know was going to happen in this trial. I can't believe it. Like, the public only heard the glove, and I don't know, maybe I was living under a rock back then. But yes, Terry, you are. Terry, this is the last one. And you're in pain. That sucks. That sucks. I hate that. I hate that you're in pain. But this isn't going to help your pain because this is painful. If we stopped yesterday in the middle of closing arguments because of a sidebar. And I think, I just think, I don't know. Hi, Chinny. I think this might be our last OJ sidebar. Marsha and Shaq, alone. No court reporter at the sidebar. And I'm hoping Shaq is getting reamed out right now. What I'm hoping is I see him walk over to the desk and pull out his checkbook. Sanctions. For objecting to everything that he is forcing her to say. Because when he was up there, he made some statements, and now she is defending what he said. But this might be the last sidebar of the OJ Simpson trial, right here, right now. Who knows? Maybe there'll be another one. I don't know. I hope he's getting reamed out, and there isn't. But it's a long one, too. Hi, Maria. It's a long one. They went over there at 14 and a half minutes into the video, and they don't come back for 18 and a half minutes. So the judge is yelling at them the whole time. Oh, let's press play. Let's go. Let's finish this trial.
All right. Thank you, counsel.
I checked the audio 6 times before I started. Don't worry.
It was also represented that Dr. Lee and Dr. Bodden both agreed that the amount of struggle would have been a very long one. Dr. Lee, in fact, didn't say that. He said something a lot less certain than that. And I'll read to you what he said. Can you tell us blow by blow what happened here? Answer, no, I cannot. That's a good question. Question, all right, thank you. And doctor, would it be fair to say that if we cannot tell blow by blow what happened here, you cannot tell blow by blow what happened, then it's difficult to give any kind of a scientific estimation of time? Answer, that's correct. That's what Dr. Lee said. Now, with respect to Dr. Bodden, it was represented to you that Dr. Bodden said the perpetrator would have been covered in blood. That's not true. You can have all of Dr. Bodden's testimony read back. I went and looked at it. It's not there. He didn't say that. He didn't say it. Not only that, but their own expert, Mr. McDonnell, had some interesting things to say about what kind of blood or how much blood you'd ever expect to find. As a matter of fact, we read the title into the record. Absence of evidence is not evidence of absence. This makes sense. A crime can happen in many different ways. Use your logic, use your common sense. If you're standing behind somebody cutting their throat, they're bleeding out, and they're not bleeding on you. So you'll get some on your hands, maybe you'll get a little bit of spatter, but you're not going to be covered in blood, and you're certainly not going to be covered in the kind of blood that you're going to track into the Bronco because it isn't getting on your back. And that's why when you think about this, think about it logically, but don't let the record be misrepresented. You want it read back? They will do it for you. They will do it for you. And don't hesitate to ask, ladies and gentlemen. Don't hesitate. The most important thing is that you base your decision on what's there, what's really there. Not on what some lawyer tells you is there, not on what you wish was there or I wish was there. What's there? I know you'll do that. Do you want me to break?
Yeah, take a break at this point. All right, ladies and gentlemen, we're going to take our noon recess at this time. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. We'll stand in recess until 1:30. All right, back on the record in the Simpson matter. All parties are again present. Jury is not present. Mr. Scheck, you wanted to be heard on page 43-200.
Yes, sir. A few things to say about that. First point to be made is that I think in Ms. Clark's argument, she started to say that there was a statement there was nothing around the glove, but Dr. Lee stated differently. Now she starts with the question, Dr. Lee, when you were at the Rockingham location, did you have occasion to find any item that your forensic opinion was consistent or appeared to be blood in the area of the air conditioning unit near Cato's house? Answer, yes, sir. That's all that's in the record at this point. Now, as the court noted at the bench, I would say there's three reasons, at least, that this was improper comment and that we should have an instruction to the jury, which is my request, that there is no evidence in this case Dr. Lee found blood on the air conditioner. And it's for at least these three reasons. Number one, there is a clear ruling in this case by this court that we've all had to live by, that presumptive tests are not admissible for showing that blood was present. And that is a clear ruling. There was a ruling that in the impeachment of Dennis Fung, that I had opened the door with respect to the Bronco, and the court made a limited finding that they could offer testimony about the extent of presumptive testing in the Bronco. So they know that that rule is in effect, and we've all lived with it and been very careful with it since. So that's point number one. Point number two, as the court noted at the bench, when one goes on to read the rest of the testimony of Dr. Lee in this area, the answers that were elicited were not that he had found blood on the air conditioning when Mr. Goldberg went on and continued asking him the question. And in fact, as I had noted on the record, and I'll get to the third point here, that he cut off Dr. Lee when Dr. Lee was about to give a further explanation when he indicated that he had done presumptive tests on the doorknobs, some sink traps, and air conditioner. And then Mr. Goldberg says, I'm just asking about the air conditioner. Answer, I saw in different places, and that's just about tests. And then Mr. Goldberg said, that's all right, Your Honor, I'll move on. I think he answered the question. Now, I came back the next day.
Is there a report by Dr. Lee that says that he did any testing there?
Yes, he did presumptive testing there. But I came back the next day, and it said 43380 of the record. And what happened, Your Honor, is that I indicated to the court at that point. Have you read this?
No, I didn't. I don't have the 43380.
Oh.
Mr. Byrne, give me the next volume 214, please.
Yes. I came back the next day, Your Honor. I think it actually starts at 43379. I came back the next day and made an objection on the record. And what I pointed out was that when I listened to I had thought that when Mr. Goldberg at this time, this is what I indicated on the record, said, that's enough, Dr. Lee, that what he was doing was trying to cut off the witness so there would not be testimony about presumptive testing, which would have violated...
No, this is about a 2-hour stream. We might go over a little bit, but this is just a 2-hour stream. They deliberated for 3 hours and 35 minutes. The jury did. Hi, Bren.
The court's rule. And I thought that that's what he was doing. When I listened again the next night to the tape, because frankly, all these commentators were saying, oh, there's evidence of blood on the air conditioner.
You didn't really listen to those people, did you?
Well, no, I listened to the tape of the testimony. And when I listened to the taste of the testimony and the implication, I became concerned.
What page?
I think it starts at 43379 and goes on to 43380.
All right, proceed.
Do you see where I'm beginning? It was just before we took up the issue of the Furman tapes. Should I read it, or is the court's reading?
I'm reading it right now.
Okay.
I don't
All right,
understand
I'll
what's
read
going
the,
on.
43379 through 43381.
I missed something. Someone help me catch up. Scheck was just delivering. No, Marcia was delivering her closing statements. Then they had a sidebar. What did the jury just, did the judge kick the jury out of the court so that they could talk about it? How did this happen? What's going on? I missed something big.
As that, I think, record indicates that I immediately approached the court and I said that I was fearful that, even though it wasn't explicitly stated on the record, that the prosecution might argue that there was blood found on the air conditioning from the way that questions and answers were brought out and the way Mr. Goldberg cut them off, and that I had misinterpreted Mr. Goldberg. He was cutting it off for purposes of putting this inference, which was improper in the first place because of the ruling on presumptive tests on the record, instead of trying to cut Dr. Lee off before he got into an area that was improper. And in fact, as I indicate in the record, that Dr. Lee was about to say that presumptive tests on sink traps, metal surfaces like air
gave the jury a
conditioners,
break.
doorknobs,
I understand.
and on
They
that
gave
kind
the
will always
jury
give
a
false
break.
positives because of the nature
Yes.
of the metal
T,
surface
you're
and
right.
bacteria, etc., which was what he was about to testify to, and they knew it because in interviews with Dr. Lee, that's what he had said. In any event, I won't. That's what Dr. Lee told me, and I offered to bring in an affidavit to that effect. And then the court indicated, as I put that objection on the record, and it was clear, and I thought, in effect, the court had ruled on that with respect to indicating to the people that that timely objection had been made on the record, and if they wanted to come forward and make this an argument, they were going to have to present arguments to the court that this was a fair inference from the evidence. I thought that's how the record stands right now. And they should, and this kind of comment, given the fact that the court had made a clear ruling in this case that presumptive tests are not proof of blood, number one. Number two, that the testimony itself does not support that contention. Number three, there was a timely objection noted on the record to the court, giving the prosecutors clear warning that if they wanted to make this argument, they better come in here and persuade the court that it was fair comment on the record. All of that being said, it seems to me highly improper and against the rulings of this court, for them now to argue that there's blood on the air conditioner reading these questions and answers. It's not what the record states. It's not what the ruling this court is. It's misleading to the jury, and we're entitled to a curative instruction to the effect that there is no evidence that Dr. Lee found blood on the air conditioner. Highly improper argument, clear misconduct.
Ms. Clark.
I'm going to allow Mr. Goldberg to address it since he was the one that did the questioning. But I remind the court that the record says exactly what I read to the jury.
Thank you, Your Honor. Good afternoon.
Good afternoon, Ms. Goldberg.
The issue of presumptive blood testing is one that we've addressed on a number of occasions with Your Honor. And the state of the record was that presumptive blood testing does not come in. We have abided by that, although the defense has not. They asked Mr. Lee questions about the walkway.
Can we just appreciate how hard Kardashian has worked in this trial? Look at him. Look at him. Dedication. He has worked tirelessly every day, sitting right there.
With respect to parallel line imprints on June the 25th that he photographed, those were presumptively tested. There were no confirmatory tests. Dr. Lee offered the opinion that they were blood, in his opinion, based upon his forensic knowledge, and was not specifically asked by counsel to testify that he had done blood testing, and that's how he knew. So he was basically relying on his generalized training and experience. It looks like blood, therefore it is blood. The basis for that opinion, we know, outside of the record, is a presumptive blood test. That came in. The court allowed it in. Then with Mr. Bodziak, counsel asked again questions about Mr. Lee's presumptive blood testing, and even called it that, blood testing, even though Mr. Sheck and I had an agreement outside the record that he would not raise the subject of presumptive blood testing with Mr. Bodziak without first clearing it with the court. And he just went ahead and did it on 2 occasions. I put before the jury the fact that presumptive blood testing has taken place. So I don't understand all the ins and outs and the exceptions and the rights and the wrongs with respect to the court's ruling. All I know is that it seems to be that when the defense wants to establish that something's blood, they don't seem to have difficulty doing it, even if the only basis for it is a presumptive blood test. And that being the case, we believed properly that we could do the same thing. Now, in this question that I asked Dr. Lee, I did not ask him about presumptive blood tests. I simply asked him, all right, now in addition to that, doctor, when you were at Rockingham location, did you have occasion to find any item that in your forensic opinion was consistent or appeared to be blood in the area of the air conditioning next to Cato Kalin's house? Answer, yes, sir. No question about forensic blood test. I'm asking him based on his experience and training as a forensic serologist, a very highly regarded one, whether it appeared to be and was based upon his forensic opinion. Then I asked him, and was that something that you believe that you thought appeared to be blood? Answer, I test some doorknobs, some sink traps, and air conditioner. I'm just asking you about the air conditioner. I saw in different places. period. There's no indication from the transcript that I cut him off. And I said, that's all right, Your Honor, I will move on, because I was fearful that he was going to start talking about presumptive blood testing, which he had not to heretofore. He simply told what appeared to be the case and what his opinion was as a forensic expert. Now, the court has allowed police officers to come in and say something appeared to be blood, or I thought something was blood, or even something was blood. And we know California courts allowed this, and Your Honor has allowed this in this trial. And I don't know why the world's perhaps most highly regarded forensic serologist, Dr. Henry Lee, can't come in here and tell us that something based upon his experience, his training, and his observations appeared to be blood. That's what this is. Now, as to the good faith belief, other than that it's in the record, and Dr. Lee has never been shy about trying to qualify and explain his answers, we also have a good faith basis because we have a report in which he said the same thing, that he tested this with orthotolidine test, which is highly reliable, which Dr. Lee regards to be reliable, and that it got a positive. I do not believe that I ever spoke to Dr. Lee about this question in my conversations with him at all. And that.
All right, Mr. Goldman, let me ask you this. Did he indicate that he saw something that appeared to him to be blood, and then he tested it with orthotolidine?
In where?
In his report.
In his report, there was a red stain that he tested, and with orthotolidine test, and
On
it
the
was
air conditioner.
on the air conditioner, and it was positive for blood. So that was the good faith basis for my question. Now, on the as to the materials that are starting on 43-380. 79 of the transcript, I was unaware of this, that this conversation even took place, because I was not in court during it, and was not aware until counsel made this argument during Ms. Clark's argument. I know how Your Honor has conducted this case, and I know, based upon the experience that I've had in this court, that Your Honor would not have ruled on an issue like this without my being here, and you did not rule, because this was my area, it was my witness, I knew this testimony, and I would be the person who was prepared to deal with it. Now, on 43-381, Your Honor says basically, well, Mr. Scheck says on 43-380, lines 27 to 28, I just want to make clear that we have an objection to that. And then Your Honor says, all right. And then on 43-381, lines 13 through 14, Your Honor says, this is a comment for the purposes of making a timely objection. I take it then, answered by Mr. Scheck, right, the court, all right, let's launch into the McKinney matter. And then you continue on with the 402 hearing on McKinney. So there is no ruling whatsoever with respect to this issue. If counsel wanted to make a motion to strike, I suppose that could have been done. We've closed evidence. We have introduced all of our exhibits. Ms. Clark is arguing about something that is in the record. She read it verbatim. She is entitled to do this under the court's rulings. And I do not see any basis whatsoever to prevent Ms. Clark from continuing on this line very briefly of argument. It's an important point because it's directly contradictory to what Mr. Cochran represented to this jury, and that she should be allowed to proceed on this issue.
First of all, it would seem to me that there's a clear question of waiver as to the whole argument he just made now, for a very simple reason. I came forward and put this objection on the record the next day, indicating that it would not be Dr. Lee's testimony that that was blood because of the false positives from testing sink traps, strains, etc. And that would have been his answer to the question, and the record is ambiguous and misleading with respect to that because he cut us the answer. So I put them on notice. It is not an excuse that can be tolerated at law that somebody sitting at this table the very next day after Dr. Lee got off the witness stand, didn't go upstairs and tell Mr. Goldberg that this was said so he could come back down and we could settle the record on this issue and it could be clear what could be offered in closing argument and what couldn't be. That is not an excuse. Lack of continuity in the district attorney's office or the fact that nobody will call him up so he can come down and argue this as though the rest of them here are incapable or don't understand this issue is not an answer. It's clearly waived. It is clearly waived. And what is particularly nefarious is that all of a sudden this issue arises during rebuttal. This is planned, Your Honor. It was exactly what I objected to. It is an unfair inference from the evidence. It is not supported by the record, even of the questions and answers, and it violates the clear instruction that we were all operating under here. It is in bad faith because I indicated that would not be the answer that Dr. Lee gave to the question. And it is quite different to be saying at certain points in time, I look at stain and I say, you know, the black imprints could be consistent with blood. And they can certainly make objections and settle the record at that point. I made my objection. I made it clear. The ruling was clear. It is outrageous for them to be arguing that this is blood on the air conditioner from this part of the transcript. When the record was made, their opportunity to correct it was there. They have to come into this court, and it's just outrageous.
All right. Thank you, counsel. The question was to Dr. Lee, did he see anything that, in his opinion, was consistent with or appeared to be blood in the area of the air conditioning unit near Cato Kalin's bedroom? And the answer was yes. And then the question later was focused back on the air conditioner, and the answer was, I saw in different places. And that's the state of the record. There is no mention of presumptive testing that was done. Although Dr. Lee's answer does say, I test some doorknobs, some sink traps, and air conditioner, and I accept the representations of counsel that what was done is the orthotolidine test. The fact that Dr. Lee, I think, is competent to say I saw something that appeared to me to be consistent with blood. The problem is that it was not confirmed. I'm going to direct counsel to move on from that topic. All right, let's have the jurors, please.
Montage for the defense that Mr. Cochran indicates he'd like to interpose an objection to. Let me indicate to the court that what it is a synthesis of evidence that has been admitted already.
All right, may I see it?
Yes.
What is the connection between the audio and the montage? Is that the audio that you anticipate playing at the same time as the montage?
Yes. It goes in tandem with the argument that's going to be made to present it, which is the motive for the murder.
Do you think the tape directly relates to the last two photographs?
I'm sorry?
Does the audio tape directly pertain to the last two?
I'm sorry, the last.
The last two photographs.
Yes, that's the point. That's the case, Your Honor. That's the whole, that is it. That the motive for these murders
Okay.
is the nature of the problem, and that's why she wound up there. We're synthesizing the evidence. You know, we do it through verbal argument, saying we have the motive, and it carries forward and up till the date of June the 12th, and then we do it with pictures. Pictures that have been admitted in evidence. All of this has been admitted.
Mr. Carter?
This is unfair. It's incredibly inflammatory. Those tapes have nothing to do with the photographs that are up there. If she wants to argue that, then so be it. This is improper rebuttal, Your Honor. They try to spring this on us at the last minute. The tape that she's referring to is a different time than the photographs. It's a photograph from 1989, tapes from 93, and the pictures, they try to link all these things together. They have nothing to do with this evidence. This evidence of other offenses was limited for a very limited purpose, and the court is aware of that. The reason it was in there, and this would be incredibly unfair and is typical of what the prosecution is doing in this rebuttal. This is outrageous, Your Honor. They're vouching, they're doing all of these things, taking things out of her where they know they're wrong, yet they're trying to do this. At the 11th hour, when she has maybe an hour or so left, we're faced with this. This is outrageous, Your Honor, and you should stop it. They held this back, to keep us from dealing with this until the last minute. Now we see it at 1:55 on the last day of her argument. This is outrageous, Your Honor. And the court should put a stop to it. This is the end of it, and we should get on and get this case to the jury. They're never going to stop unless you exercise your wisdom and discretion and stop it.
Thank you. Ms. Clark?
Your Honor, I don't think that Mr. Cochran has the right to use the word outrageous. This is a man who argued Mark Fuhrman was commensurate with Adolf Hitler. This is a man who demanded jury nullification. But this is proper argument.
Let's address the issue.
Yes.
Are these items in evidence?
They're all in evidence, Your Honor. And the purpose for which we're using the tape being played over these photographs is the very purpose for which the domestic violence matters were admitted, which is for the purpose of motive and identification. And that's why it's been synthesized this way. I think we're using it to an entirely appropriate purpose, as the court has permitted us to do, with the jury instruction that limits it. We have, I think, appropriately argued it. Mr. Darden's appropriately argued in that vein. But this is argument, and we are synthesizing all of it. The domestic violence is the underlying theme in the case. It is certainly the motivation in the case, and it goes to identification as well.
All right. I think the record is not completely clear because we did not identify what all these items are. But what we started out with were photographs of the domestic violence injuries, the Polaroid photographs.
Yes, Your Honor. I should be more specific. They are the domestic violence photographs with respect to the 1989 incident. Then I believe they are the photographs from the safe deposit box. And then we have the photographs from Rockingham that pertain to this case, and they conclude with the photographs of Bundy pertaining to this case.
And this is while you're playing the first portion of People's Exhibit what?
What is the number?
This is the 93
You are very naughty.
tape.
Book 89 and the 93 tapes.
Your Honor, may I say something when you get an opportunity?
Ms. Clark, you concluded with your argument?
Yes, Your Honor.
Your Honor, in the 93 incident, as you're well aware, the tape they played, there was only the French doors were damaged. There was no physical anything. In the 89 incident, they ran these two things together. They have nothing to do. They're juxtaposing. This is an interpretation they're placing on the evidence. If they want to show the evidence, that's one thing. But to play the tape in conjunction with that, that's a production from the district attorney's office at this 11th hour. And it's unfair. It's absolutely unfair. It's inflammatory. This is improper.
That's a production from the prosecutor. If the glove don't fit, you must acquit. All you do is production. Your whole closing statement was nothing but theatrics. Sir.
rebuttal. We've seen all this evidence in addition to that. The court has told us on several occasions you're going to...
You see all the evidence that they're trying to talk about in the closing statement? Yeah, that's what closing statements are for. To talk about the evidence that you've seen in a production type way. Come on.
Stop us when there's redundancy, and
Good-
this is
good idea,
absolutely
Brad.
redundant. It is improper. The prejudice far
idea.
outweighs any probative value because they're meshing things that don't follow. They do not follow. This evidence was limited for a limited purpose, and they're tying things together and making a conclusion, just as she did with this incident regarding the air conditioning. And that's unfair. Vouching for things, it's wrong, Judge, and it shouldn't happen.
Is that the word for the day?
Vouching?
Yes.
Vouching is the word for the day, Your Honor.
Thank you.
The I word, and it's personally vouching, and it's wrong, and they know it's wrong, and everybody knows it's wrong, and it shouldn't happen, Judge.
Ms. Clark, I do think it is a problem with the soundtrack because you've run the two soundtracks together, the 80, 89. Is this two tapes?
Both of which have been admitted.
I understand. It's misleading because you can't tell that they're two tapes. There's no break with them.
Well,
is
I'll
my
tell them.
concern.
How about if I tell the jury we're running them together?
When do you anticipate doing this in your argument?
At the end. I'll introduce it. I'll explain to the jury we've run the two tapes together, and as I have to. I have to tell them what they're seeing and hearing. I don't want to mislead them. I want to tell them the truth. I want them to know exactly. I want them to hear exactly what it is that they're hearing. I want them to know. That's the 89 tape, and then we're going to run the 93 tape, and we're going to run the pictures from 89. We're going to run the pictures from the safe deposit box. I want them to be very clear about what they're seeing and hearing. I don't want there to be any mistake about it.
All right. With that caveat, the objection's overruled. All right. Let's proceed. Let's have the jury, please. Ladies and gentlemen, please be seated. And let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon again, ladies and gentlemen. And Ms. Clark, you may continue with your concluding summation.
Thank you very much, Your Honor. Good afternoon, ladies and gentlemen. I forget where I left off, so I'm just going to pick up with something else. There were some remarks made about the treatment given to
There's only
some of the
10
witnesses,
people here,
and,
Kelly.
And I confess that there are probably some I could have been nicer to. Mark Partridge came in to testify to the defendant's demeanor when he came back from Chicago, and this kind of it's a really good example of what I'm talking about. He made notes, detailed notes, the next day, you might remember, of everything that the defendant said to him and everything that he said to Mr. Simpson, and he copyrighted them.
There's 7 people here. We lost 2.
That means you have a proprietary interest in the material. The very next day after he speaks to him, he's going to sell these notes. He's going to make some money off of this. He's got some proprietary interest in this. Now, what kind of a man is that? What kind of a person is that? And it's very indicative. It's very, very consistent. You heard from Ellen Aronson. She came up to testify. She was the one, she called into the police to say that she initially said that she heard the dogs barking at 11:30. Then she saw the preliminary hearing and she realized, I better call back again and change the time so I can make myself a witness. A groupie. And yeah, I don't like that kind of person. That doesn't belong in a criminal trial. That's the kind of person that's going to...
Sustain. Counsel, rephrase that, please.
Okay. That's the kind of person that will offer any testimony they can to get their 15 minutes of fame. That's not the kind of testimony you can trust. At the end of the trial, or at the end of the people's case, we had, or maybe it was a whole trial, the judge took judicial notice of something. And I'm sure you were wondering, what did that relate to? And the judicial notice that he took was that the moon on the night of June the 12th was a crescent moon, 12% illuminated. You may recall that. That's very important for 2 reasons. First and most important reason is it tells you what the lighting conditions were like that night. It was not a full moon. It was a dark night. Witnesses, their testimony has been referred to by Mr. Darden, have confirmed that. It was dark. Officer Risky made it very clear. It was dark. Super Bostepi, who was walking with the dog, who said, I would not have looked up there. I wouldn't have seen the body if the dog had not stopped and looked up the pathway. That's important. So you have that judicial notice taken. That means it's an undisputed fact you are to accept, a 12% crescent moon. When I cross-examined Ms. Aronson and I asked her what was the moon like, oh, it was a full moon. Are you sure? Yes, I'm very sure. It's in the record. Have it read back. She was very sure. She was very wrong, too. She also testified that she was very sure that she called the police officer to give her statement to him the first time on June the 14th. I showed her the police report. It said June the 15th. Are you sure? I'm very sure. She's very sure about a lot of things, but one thing she really didn't know was when she was walking down that street. And you know how else you know that she wasn't down that street when she said she was? Because Mark Storfer said he looked out his window at 10:23. I read it, I reviewed it, and now I'm so tired I can't remember it exactly. You can have it read back because I think that what he said was 10:23.
Excuse me, counsel.
In any case,
There's some objection. Please stop.
I'm sorry, I didn't hear.
All right. Counsel. Remember, you're the judge of the facts. You're the sole judge of the facts. Thank you, counsel. Proceed.
Yeah, and you know, if you have a doubt about something I'm saying, please have it read back to you or look at your notes, okay? Because I'm not trying to play fast and loose here. But it was within 2 minutes of when she passed Bundy that he looked out his window. If she's walking down Bundy and that lights-colored outfit that she said she was wearing on that night, he should have seen her when he looked north on Bundy, because he said he looked out the window, looked north, and he saw no one walking there, which is actually consistent with the other witnesses who don't say that they saw anybody either. All of the witnesses that were called by the defense somehow were in the same place, but none of them saw each other. It's very weird. Defense has raised the issue about there being, why wasn't there dirt? Why wasn't there mud at Rockingham, tracked in the house on that light carpet? There wouldn't be. There was. You saw the bloody shoe prints, and they faded out halfway down the Bundy walk, to the point where there were no visible bloody shoe prints on that walk at the end of the walkway. Then you saw the imprint in the Bronco, so that whatever blood was left on the shoe was picked up by the soft tufts of the carpet. By the time he gets back to Rockingham, there isn't much left there. Whatever blood, whatever mud, whatever dirt he's got on his shoes, he's tracked off. This is common experience, you know. Your blood or mud, whatever you get on your shoes, doesn't stay there forever. You walk, it comes off, and as you walk, more comes off. By the time he gets home, there's not a lot of excess there. Maybe there's some trace amount, but you're not going to notice that on a carpet. And so that in itself says nothing. And the testimony of their experts, Mr. McDonnell, I think even Dr. Lee, does not dispute that. Of greater importance, and I think actually, yes, Dr. Lee even testified. He was asked specifically, if somebody walked through dirt, walked through berries, would you necessarily see it? And his answer was, you might see it, and you might not. The absence of evidence is not evidence of absence, and that's what their witnesses have said. Now, there was an issue raised with respect to EAP. That's a conventional blood marker, okay? And you may recall there was testimony that Nicole Brown had an EAP type of BA. The blood under her fingernails was typed and came back with an EAP of B. We had testimony from Greg Matheson to indicate to you that that was degraded, that the BA degraded to a B. In order to confirm that it was her blood and not the blood of someone else, they did DNA testing on that blood. And the DNA confirmed that it was hers. It was her blood, and that it had degraded. And it had degraded because, number one, the EAP marker degrades very rapidly. Number two, her hand was in wet blood, and blood in a wet state degrades quickly, more quickly than it would on a dried gate, for example, or in a dried condition. Now, there's more to that. First of all, Gary Sims agreed with Greg Matheson in his conclusion that the blood under her fingernails was hers and not that of another perpetrator. But the
Overruled. Excuse me, counsel. You need not make that objection any further. I've instructed the jury that they are the sole judges of what the facts are in this case. And if counsel chooses to argue a line of argument that is in contradiction to what these jurors find to be the facts, they do so at their own peril. The objection is made. Thank you. Ms. Clark.
Thank you. Moreover, Dr. Lee, who was called by the defense to testify, never contradicted that. And he agreed that Greg Matheson was a good scientist. There was some testimony, I think, from Dr. Bodden that you can get somehow the blood of someone under your nails without getting the skin under your nails. I don't see how that can possibly happen. But what is interesting...
Overruled. Overruled, counsel.
What is interesting is that the defendant's EAP type is also a BA. Also. Now, the blood on the rear gate, that blood that came back to the RFLP testing, making the defendant 1 in 57 billion or something, obviously it's an identification. That's his blood. There's not even any dispute about that. That's his blood on the rear gate. That blood also had an EAP that was a BA degraded to a B. That blood also...
Hold on. Counsel, with the court reporter, please.
And Judge Ito made me a frickin' liar. But, okay, we're not going to count that as a sidebar. Even though it clearly was.
All right, thank you, counsel. Ms. Knoxon, are you ready? Proceed.
I'm going to finish today, ladies and gentlemen. I promise. I promise. Okay. But it's just so important. I really want the record to be straight. I want you to know. This, on the rear gate 117, okay, there was testimony to indicate that Mr. Simpson's EAP marker was a BA. So is Nicole's, a BA. There was testimony in the record indicating that a BA can degrade and turn into a B because the A bands drop off. That was early testimony. That's what happens. It can degrade that way. That was the testimony. The blood under her nails that had the DNA that piped back to her also had an EAP result of B, which Greg Matheson testified was indicative to him that the EAP marker had degraded, that the A bands had dropped off. That was his testimony. With respect to the rear gate, he testified as well. That's the rear gate where the defendant's blood is. DNA came back to him. The EAP marker, that he has a BA just like hers, became back degraded to a B. And here's the testimony that he gave. He stated as follows. And was 117 identified as being one of the rear gate stains from the Bundy location? Answer, yes, I believe it was. And you got a B-like pattern on that? Answer, I called it a B question mark inconclusive, yes.
Proceed.
I just read it to you. If you want to have it read to you, ladies and gentlemen,
I've ruled. Proceed.
the page number is 25,965 if you want to read it again. What that indicates to you, ladies and gentlemen, is that there was also testimony, I should tell you. There's another conventional marker for serology called PGM. Maybe you remember that. And the PGM on the rear gate was also degraded. There was testimony, I believe, from Greg Matheson about that as well. That's important for a couple of reasons. Number one, with respect to the blood under her nails, what it indicates is that it's her blood. It's her blood. Number two, what it also indicates is that the blood on the rear gate was degraded. There was PGM degradation and EAP degradation, which indicates to you that it was out there for a while. It's all in the record. Very logical, and it's very consistent. I could go into greater depth on this and talk about, what they're trying to tell you, ladies and gentlemen, is that a very, very sensitive, what they call exquisitely sensitive test in the PCR, picked up Nicole, but not the blood, not the blood of the real killer that was under her nails. Well, how could that be? Conventional serology is not nearly as sensitive as PCR, not nearly. So the EAP marker that Greg Matheson testified was breaking down under her nails, that isn't nearly as sensitive. They want to point you to that and say that's the blood of the real killer, in contradiction to the testimony of Greg Matheson and Gary Sims. And yet we have very sensitive DNA testing that says it's hers, and they say ignore that. It doesn't make any sense. The blood under her nails is hers. That's what makes sense. That's logical. There was also testimony, and there was also some points made about bindle number 47, the infamous bindle number 47. That's one of the Bundy blood trail drops. And in that, Dr. Lee testified, I believe, that there was the bindles that were placed into, the swatches that were placed in the bindle were obviously still wet when placed in there. And some of the sizes and shapes of the swatches matched the imprints of blood on the bindle, and one did not. And a big deal was made about this. I'm not really sure why, because it's inconsistent. Remember I told you I'd point out inconsistent defenses? Their defense seemed to have been all along that the Bundy walk blood drops that all came back to the defendant were contaminated, right? Well, with this testimony from Dr. Lee, it would seem they're trying to say that there was some kind of planting going on because one of the little imprints in the bindle didn't match. I don't know which one they want to choose, but the truth of the matter is that Colin Yamauchi said he took one of those little swatches out for testing. So, of course, there's going to be one imprint there that doesn't match the swatches because one of them's gone. He tested it. There's no big mystery here. It's very simple. It's very, very, very simple. And it's interesting that they really did not tell what they don't make a big deal about, which I don't understand, and was testified to, is that item number 42. Item number 42 is Nicole's blood pool. Remember I told you that they took a representative sample of the blood underneath Nicole and the blood that was right near Ron Goldman in the tree stump. Okay, his was number 41, hers was number 42. Number 42 then was her blood. And in that one also they have imprints. There was one imprint, I think, that there was testimony that didn't match the size of the swatch. What, they're planting Nicole's blood? You know, that would be the logical inference to be drawn. in her own blood pool? That would be ridiculous. But you see what I mean? That exposes the fact that all of these arguments about the minutia make no sense when you look at the big picture. You look at the big picture and you realize, well, there's nothing sinister here. You know, open the doors, open the windows, let in the light here. Blow out that smoke. Because when you look at the whole picture, you see the truth. It's very, very simple. All right, I'd like to talk to you a little bit about contamination. There was a lot talked to you about that during this trial, I know. And it really is not as complicated, and it really is not as easy to do as they've been making you think. And I'd like to show you what I mean by that with a few slides. I'm going to try not to say things like substrate control and reagent blanks and all that stuff. I'd like to talk about it the way I talk about other things, everything else in my life except for the science stuff. All right. Here are the reasons why you can have faith and you can rely on the validity of the results of the testing of the Bundy blood trail. Number one, you've heard us talk about it too many times. The substrate controls were clean. Okay? They should have showed contamination, and they didn't. And they were tested, and they came up clean. And what that gives you is quality assurance. You know you can rely on the result because you have this. The bindles were closed. That's very important. Remember, if you will, the testimony concerning opening of the blood vial, the defendant's reference vial. And they were saying that when the blood vial was opened, that somehow contaminated the bindles and the swatches that were taken from the Bundy walk, that there was some aerosol effect and his blood was spraying all over the place. Well, the problem with that is that Collins' testimony was when he opened the blood vial of the defendant's reference blood, he was 10 to 15 feet away from the swatches, and these swatches were in closed bindles. And not only that, but the bindles were inside envelopes that were closed. Now, what testimony have you heard in this trial that DNA can fly from a test tube into a closed envelope, through a closed bindle, onto the swatches? None. In fact, there's testimony to the contrary. And that brings us to next. There was no vacuum in this test tube. This was not a vacutainer. This was a syringe, and it's already been shown to you. And the testimony was...
Give the counsel not a syringe.
I'm sorry. Isn't that what the test... Spinoparatus?
No, it's a vacutainer tube.
Nope.
No.
Nope. He said it was a syringe, not a vacutainer.
That's Stanford. He said a syringe.
He said a syringe.
There's no vacuum in the tube?
We'll see.
You had the tape. It was not a vacutainer that was used. It was a syringe. And there was testimony concerning this from Colin Yamauchi as well. And by the way, while we're at it, let me point out something else. Mr. Scheck argued yesterday that Colin Yamauchi, when he opened up the defendant's reference vial, spilled blood on his gloves and spilled it on the chem wipe. And it sounds to me like he was spilling it all over the place. And I guess if that's true, then there is no missing blood because it got spilled. But the truth of the matter is, and the testimony was, that as Colin Yamauchi told you, when he opened it, he thought he might have gotten a little bit on his gloves, and that he immediately changed his gloves and threw them away before he went to handle anything. So you don't have any problems with flying DNA, and you don't have the kind of, you don't have the contact that you need to have in order to show contamination. And by the way, I should indicate to you that Gary Sims, whom the defense endorses as being a very good scientist, indicated that he too has had the experience of opening a reference vial and getting a little bit of it out, and then you just, you wipe it off, you clean up, it's fine. Okay, all of the swatches that were tested on the Bundy walk were consistent. They all came back to the defendant. That's important for the following reason. If you have contamination, what you should expect to find are results that are out of sync, willy-nilly, if you will. What should have happened is you should have seen the defendant's blood type coming up, for example, in the sample that was taken from the pool of blood under Nicole, where it shouldn't be. You know, remember I told you about 41 and 42? 41 came from the area near Ron Goldman. There was a tree stump that he was curled around, and there was blood on that tree stump. And they recovered it as a representative sample from the crime scene of what his blood type would be. If this was, in fact, contamination, and the defendant's type is flying all over the place, why don't we find it in Ron Goldman's crime scene sample? Why don't we find it in the sample taken from the pool of blood underneath Nicole? We don't. If you had contamination, it should be in other places, places where it doesn't belong. But you don't have that. You only have the defendant's blood type coming up in the places where the killer dripped blood. this is the other point that was made by the defense, and in order for you to believe that the results of the Bundy blood trail were the result of contamination, you must first believe that all of the DNA on all of the swatches completely and totally degraded. Now, when you think about the fact, as was brought out in testimony, that you can recover DNA through PCR analysis from Egyptian mummies, then how can you possibly buy this story about stains that were recovered a few hours ago, completely and totally degrading, every single one of them, all of the swatches for all of the drops, completely degrading to the point where they're able to pick up contamination? It makes no sense. It's completely illogical. It stands science on its head. So this is a list of all of the reasons that I've just told to you. For all of these reasons, bindles and envelopes were closed, substrate controls were cleaned, swatches were tested and typed consistent with the defendant, which otherwise you would expect to have willy-nilly, you'd have weird results happening. Every drop in the trail would have had to completely degrade in order to pick up somebody else's type, and the DNA didn't fly across the room. Now, there's something else that you should know about this is the following. We did conventional serology. If you recall, on one of the blood drops on the Bundy walk, item number 49, we did conventional serology, and that means no DNA stuff. That's just the regular, what we call PGM markers. You heard them talk about that. We did a PGM test on item number 49. That came back to the defendant. It put him within 0.5% of the population that could have deposited that blood. So, even if you do not take into account the DNA typing, that testimony is in 40,198 to 40,199 if you want to review that. He said, in fact, that the conventional testing, when conventional serology comes back the same as DNA testing, it's a good cross-check for the validity of your results. And we have that here. We have that. Dr. Lee also told you that his lab does DNA testing. He felt that molecular biologists, like Dr. Gertie, should not tell forensic scientists what to do or how to do it or when to do DNA testing. And he said that forensic scientists are in the best position to know. That was Dr. Lee's opinion. He even indicated, and there's a portion of the transcript you could have read back, he was asked a series of hypothetical questions. For example, that an officer would go to a crime scene and pick up blood on his shoe and then go and give that bloody shoe to the criminalist to test for DNA. And he was asked, Dr. Lee, would you get valid results if you did such testing? Wouldn't you be worried about contamination because you didn't collect carefully? You just collected it by picking it up on your shoe. He said, no, you could get valid results doing that, even doing it that way. And you know we didn't do that in this case. You know we picked it up correctly in this case. All right, so we talked about contamination. Let's talk about planting. First of all, the socks. With respect to the socks, there was testimony and then there was argument about this sheet, and you're going to have it. It's in evidence, isn't it, Your Honor? The blood search sheet, worksheet? Yes, it is. Good, good. You'll be able to see it. You'll see the whole thing. The whole controversy, all the shoutings about this, and Michelle Kessler testified to it late in the trial. It showed that, as to the socks, there was a notation that there was to be a blood search done. At the moment that they looked at them, there was none obvious. Now, what the defense wants you to believe is that they had already done a blood search and there was none obvious. When you look at the sheets, you will see what the truth is. As Michelle said, it's really very simple. You can see that in the column where it says blood search, it's a scheduled item list of things to be done. A blood search was to be done. It had not yet been done. You want confirmation? Check the testimony of their witness, Dr. Baden. Dr. Baden was asked about that, and Dr. Baden made notes about his interview or his contact with Michelle Kessler early on in the case. And here's what they had to say. They were going over Dr. Baden's notes of when he was reviewing the evidence at page 41-270. Question, and what does that say? Answer, number 13, 2 dark socks, no analysis yet. Question, do you see anything written regarding no blood observed? Answer, we didn't write that down. No, there was no blood observed or else I would have included it. Question, now doctor, what does no analysis yet refer to? Answer, Ms. Kessler told me that no analysis had yet been done on the socks by the Los Angeles Police Department, and we didn't do any further analysis on it. That was the testimony of Dr. Baden. That's what Michelle Kessler told him. There was some further testimony that you might find interesting from Dr. Baden, and that's concerning how visible blood would be on those black socks under normal lighting conditions such as we're on here right now. You may recall that I asked Mr. McDonald about that a little bit. He said, no, you need high-intensity light because those dark socks, it's very hard to see blood stains on them. At page 41-272, there was questioning of Dr. Bodden that went as follows. Question: what was the lighting like at the time of your observations? Answer: not very bright. It was a little better than the better lighting than here presently, but not very bright. Question: not what you would describe as the kind of ideal lighting for conducting a close visual examination of something like a dark pair of socks. Answer: yes, that's fair. Question: there was no high-intensity lighting, was there? Answer: that's correct. Question: and high-intensity lighting is the kind of lighting that you would like to have when conducting a close visual inspection of an item like black socks, right? Answer: that's correct. Yes. Big mystery. Now, what's even sillier about this argument, number one thing, it seems that what the defense is arguing here is that somebody went and took the socks out of the hamper and put them on the floor. First thing I ask you, ladies and gentlemen, why? Why? Why not just come in and say, we went through his hamper, we found the socks, we took them? Why not? What difference does it make? It makes it more incriminating somehow that the socks are on the floor? It doesn't matter. The question is what's on the socks, not where the socks are. They're in the hamper, they're on the floor, same thing. No difference. If you'd rather consider them as having been in the hamper, consider it. That's not the way he left them, but, you know, what's the point of doing something like that? That's silly. That makes no sense. Now think of this, too. Why would you, it would seem that what they're basically saying, there was no blood on the socks. That's what they're saying, right? Why would you plant a blank pair of socks and then go back 2 months later and say, I forgot I was supposed to plant blood on them. What have I been thinking? I got to go back and put the blood there. Does that make any sense to you at all? I mean, there's no logic to this. This defies common sense. You have to buy this. You have to buy that story, or else the defendant is guilty. That's it. And who could think like this? I mean, this is not only tortured logic. This is out the window. This is over the line. This is, talk about doesn't pass the laugh test. Only it's not really very funny. It's not funny what they're saying, but it's crazy. Now, so then they give you the stuff about the surface 3. They have these little microscopic red balls that they talk about. Now, the truth of the matter was that the testimony from Mr. McDonnell and from Dr. Lee, I believe, but certainly Mr. McDonnell, was that he could not say that those little microscopic balls on surface 3 came only from surface 2. In other words, and if it didn't, if you can't say that, then you don't have any evidence of planting. What you have there is a couple of the other things that were indicated. For example, you saw the photograph of the socks. They were inside out. The toe was lying on the ankle. And we know that his blood was on the toe. With his blood lying on the toe, pressing on the inside of the ankle, that would be on surface 3, you have the possibility of transfer right there. Another possibility that was pointed out was the phenol test, where you can see the photographs. There's a drop there of moisture in the photograph. You touch it to the sock, you swab around for blood, and then you can get a wet transfer. But if somebody goes to plant blood, first of all, why would you plant blood on black socks that no one can see? But that's another story. That makes no sense either. But assume you do. Assume you do. Aren't you going to plant enough so it will be found and it will be typable and they'll find it and they'll see it? In which case, if you do that, you don't wind up with little microscopic balls that you can't hardly see except under high magnification. You're going to wind up with something there. It's going to go bleeding through into the other side. It makes no sense. This makes no sense. And who did that? When did they do it? How did they do it? None of these things are explained to you. It's just thrown out there. It's like I was telling you, a lawyer says so, doesn't make it so. Look for the evidence, look for the proof. Look how, look when, look who. Do you have any of that? You have none of it. Not only don't you have that, but you have no logic to go with it. There's no logic in what they're saying. It makes no sense, and it didn't happen. Not only do you know that it makes no sense, but now we've proven it didn't happen. We did the EDTA test. You look at those graphs. They tell you it didn't happen. Not only have we proven our case, we've disproven theirs. How much more could you ask? The rear gate. That's another one they want you to believe blood was planted on. Now, I've already talked to you about this a little bit. They were making a lot of arguments about the blood was not degraded on the rear gate, and therefore you should believe that because there were high amounts of DNA in it, that it had to be planted. Well, we've proven that that wasn't true with the EDTA test. So you know that's not so. You have other assurances, though. As I told you, there was degradation. The EAP degraded to a B, and the PGM degraded as well. So there is degradation on that rear gate. It was exposed. But then I think it was really the most telling of all, Officer Risky, the first officer on the scene. It's been a long time since you've seen his face. He was very early on in this case. But he was very honest, he was very candid. Even defense counsel agrees. And this is what he had to say about that, page 14,068. Question. Now, when you went out through the rear gate, were you able to see any other blood drops? Answer. I met with my partner at the rear gate, and yes, I did. And question. How much and how did you happen to see those? Answer. My partner directed my attention to them. Question. And how did he do that? Answer. He just told me he saw blood on the gate and on the driveway, and he showed me where they were with his flashlight. Question. Shone his light on them? Answer. That's correct. Question. Was he staying away from them? Answer. Yes. Officer Risky is describing the actions of his partner, Officer Terrazas, who saw blood on the rear gate. They were the first officers there in the early morning hours, just shortly after midnight, June 13, 1994. Defense counsel asked, why didn't the dog run out through the rear gate? If it was Mr. Simpson there, he would have run out behind him through the rear gate. You recall that argument yesterday? You know why? Well, you already know the answer. The front gate was open, but the rear gate was closed because he closed the rear gate. And that's another reason why you know his blood is on that gate. And that's why the dog didn't run out the back. The dog ran out the front because the front gate was open and the rear gate was closed. And Officer Risky told you that too. When they got there, the rear gate was closed and he was careful not to touch it. You can have that testimony read back to you. But that's why the dog didn't run out the back. But maybe that is also why the dog, after running out the front, ran around to the back. You recall the testimony of the bloody paw prints that went south on Bundy and then went west on Dorothy towards the rear alley, going out to look for his owner? There was testimony from a number of witnesses who were present. The first of them, Officer Risky, who traced those bloody paw prints down Bundy and west on Dorothy. You can have it read back. The Bronco. Now, I think that, first of all, defense counsel wants you to believe that Mark Furman went into that Bronco, and that's why he was able to describe blood inside the Bronco that couldn't be seen on the outside of the Bronco. And let me just make a logical point to you. If he was in that Bronco doing all these nefarious things, why would he then go out and describe what he saw when he was in the Bronco doing these nefarious things, doing these bad things? He wouldn't admit to knowing anything about the inside of that Bronco. He wouldn't admit to making detailed observations of blood that's inside the Bronco. That's just a logical point. But there's more. The defense would have you believe that the extra 4 allele on the PCR testing they found on the steering wheel comes from Mark Furman. Now, defense counsel has made many, many requests, many of them. One of them was to get the officer's hair to eliminate from the Rockingham glove. And we did it. We got hair standards.
Record, counsel. Proceed.
It was a request.
No, it wasn't.
Proceed.
We got hair standards from all of the officers. No problem, counsel. Let's go look. And we did. And Mark Furman and all the other officers were eliminated from that Caucasian hair on the Rockingham glove. A similar request could have been made for the blood of Mark Furman. And it was not. And had it been asked, it would have been done. And that their requests have been honored. Had they made one, they could have been done.
Counsel, move on.
Now, with respect to the cell phone cut, I want to make a point on that. Where is that board?
Bobby, this is your very last chance to learn about UDTA, because I guarantee you are never going to study it in the future.
Okay. What's Your Honor?
Thank you.
Let me direct your attention to this one. You see the blood inside the well of the door handle on the driver's side? Inside? Okay, that's an important blood spot. If you think about it, that blood is only going to get in that spot if you are sitting in the car with the door closed and you reach to open it, and in putting your hand on that handle, a bloody knuckle touches the well. That's how that blood gets there. The door closed. You're sitting in the car. That's very important, because what that tells you What that tells you is that it means that the defendant was driving with a cut hand. His hand was already cut when he came back to Rockingham. When he opened that door, that knuckle was cut. It was cut at Bundy. That stain is very important. That stain tells you it was no razor-sharp cell phone. And it didn't happen when he was getting ready to leave for the airport. It happened earlier that night when he was out. That's what that tells you. That, of course, and the blood in the bathroom. That shows that he was bleeding earlier, before he got down to see the limo driver. Now, the allegation made about the blood on the console. If I understood the argument that's been made here, it is that the defendant was in the Bronco and he was bleeding. And he dripped some of his blood on the console. I got a problem with that already, okay? Because he was cut on the left hand. On the left hand, and that's why you have his blood on the left-hand side of the car, and you have the victim's blood on the console where he dropped the glove. That's why you don't have. Let me see if I can describe this better. On the left-hand side, you have the drippings that came back to the defendant. On the right-hand side, you have the smears, okay? And the smears came from the Rockingham glove. The Rockingham glove has the blood of the defendant and Ron Goldman and Nicole Brown. It has all three of them on there, okay? And in a moist condition, it will swipe a little bit like you see here. Now, what they're trying to tell you is that the defendant dripped blood on that side somehow with his cut left hand, dripped over on the console, and that later Mark Furman came in and just happened to take the bloody Rockingham Bundy glove that did not have the blood of the defendant on it, but swipe exactly where the defendant had dripped on the console. And somehow that's how his blood got mixed up with Ron Goldman's blood on the console. If you wanted to sell this story in Hollywood, they wouldn't buy it because it's so incredible, it's not even funny, it's ludicrous, okay? This is ludicrous. But above and beyond that, they're also saying this. They are saying that Dennis Fung collected all of the blood on the console and it was all gone. Then someone came back later and planted blood exactly in the same places it had been before to look exactly the same way it had looked before. This is ridiculous. Talk about makes no sense. Talk about just unbelievable. You'll have the pictures. You need to look at the pictures. Look at the pictures yourself. Have them back in the jury room. Compare, look at all of the pictures you can get your hands on. Compare the blood patterns on this console. The photos that were taken, this one's later. This is September 1st down here. And this one up here was on June 14th. Compare them. You ask yourself, how could this possibly happen? How could it happen that they can duplicate exactly the way the blood looks on June the 14th on September 1st? It can happen. But you need to go back and look at it. You need to get your hands on this stuff yourselves and talk about this because this is so far beyond the pale that only you're seeing yourself and holding this in your hands is believing that they're actually saying this to you. Now, the problem with it really is that you have to buy the planting theory. You have to buy this far-out idea, this stuff, because otherwise, if you don't, he's guilty. Guilty. He's got Ron Goldman's blood in his car. What's it doing there? That's it. That's it. He's guilty. So they have to find an excuse. And that's why you have this flailing about. You have contamination, you have planting, you have contamination and planting and or planting. You've got everything to explain it all away. Everything. But the theories get wilder and wilder because the proof is so devastating. There's so much of it, and there's so much to explain. Now, here's what really happened. Let's come back to reality here. The truth of the matter is that when the officers got to Rockingham, and this is the state of the record. Now we're talking evidence and not fairy tales, okay? State of the evidence is this, ladies and gentlemen. The detectives got to Rockingham. The Bronco was locked. They asked Cato for the key. He couldn't find the key. They towed it in a locked condition. And on June the 14th, Dennis Fung had to get somebody to Slim Jim the door open so he could get in there to collect the blood. That's the evidence. It's not nearly as exciting. It's much more boring, but it's the truth. It's the truth. That's what happened. And so they never did, by the way, lock the car again because they didn't have the keys. And that's why you had all that testimony about the car sitting there at Vertel's and people able to open the door. They couldn't lock it because if they did, they couldn't open it again. They'd have to Slim Jim it. That's the state of the record. That's the truth. And by the way, the blood that was collected that's shown here in the bottom photograph that has the number 26 on it on this exhibit, that blood was collected and sent directly to the Department of Justice. It didn't go through that cesspool they want to call the LAPD. It went straight up to the OJ. And it was tested, and it came back with the RFLP result of Ron Goldman and the defendant. All right. There was also, briefly, somebody made reference to Detective Muldorfer not seeing blood in the Bronco. Well, that impression, if you had the impression that she was looking for blood in the Bronco and tried to find it but failed, then you were given the wrong impression. Let me correct it very briefly. Question by Mr. Darden. Detective, are you telling us that there was no blood on the console? Answer, no. Question, you weren't investigating the issue of whether or not there was blood on the console. Is that correct? Answer, that was not the focus of my investigation. Question, the focus of your investigation was Mr. Mraz, correct? Answer, yes. Question, you had learned that he had stolen items from the defendant's vehicle, correct? Answer, yes. Question, and the items that you learned about were credit receipts. Is that right? Answer, yes. Question, your investigation was focusing on theft of items of paper. Answer, yes. Your investigation wasn't focused on biological evidence, was it? Answer, no. That wasn't her job. Now, I want to come to a very important piece of evidence, and that is the bloody shoe print on the Bronco carpet, shown probably best up here on this top photograph by the number 33. There was testimony that went to this from Mr. Boziak. Now, how do they explain that? Because that's real serious. You know, that shows, that's a very important piece of evidence. We have the Bruno Mollies going down the Bundy Walk in blood, and then we have a bloody imprint right there where you'd put your foot if you were the driver. And what does that look like? That's very highly incriminating. Now, they want to explain this one away by saying that Mark Furman stepped in the blood of Nicole Brown because actually, this is all woven in a bunch of stuff together. That photograph where you see him pointing to the evidence at Bundy, that really wasn't taken at 7 or 6:30 or something as was testified to. No. That was taken before he left to go to Rockingham. And the blood on his shoe dried. He was standing there. He was marching around in her pool of blood. That's what you have to believe. Then he went out to Rockingham. He stepped on the wet grass. He got it wet again. And when he got into this Bronco, which I guess you must have had a Slim Jim with him to break into because it was locked, he got in and he put his foot on that carpet right where you would put it if you were driving it, but he didn't have the key, so why would he be sitting that way? I don't know. But that's the story. That's what you're supposed to believe. Now, there's a bunch of problems with that story that make it impossible. It doesn't fit, it doesn't make sense, and it didn't happen. And here's why. Number one, there was testimony from Mr. Boziak concerning the characteristics of this stain. And that means 33, where the imprint is. And what he said was that there were the S squiggles that were very distinctive of the Silga design of the Bruno Mollies. He said there was not enough distinctive characteristics for him to make an absolute positive identification. But you can see, and I'm going to show you that logic and common sense and your own powers of observation tell you that's the Bruno Molly shoe. And Mr. Boziak told you that he excluded the shoes of all of the officers, including those of Mark Furman, from the bloody shoe prints at Bundy.
Take a break.
Okay.
Then I'll hear your...
Here was the testimony of Agent Boziak, page 32, 738. Question. With respect to these two exhibits, referring to the exhibit of the officer's shoes, and I'll show you those, were you able to include or exclude the officer's shoe prints as having created any of the prints that you saw at the Bundy location? Answer. I was able to exclude those officers' footprints as having made any of the distinguishable Silga design that I pointed out previously this morning. That Silga design is totally different than any of the designs of these officers' shoes. And when we come back from the break, I'll show you.
All right, ladies and gentlemen, we're going to take our mid-afternoon recess. Remember all my admonitions to you, and we'll be in recess for 15. All right, let me see counsel at the sidebar with the court, please. All right, back on the record in the Simpson matter. All parties are again present. Counsel, did we determine which of the results boards, which exhibit has the 42 results? No? Which exhibit is it?
What issue is left to resolve?
The issue is 42, and the issue is the state of the record regarding requests for blood samples or PCR results from the investigating officers. That's the issue. I think the state of the record is the request was made and declined. That's my recollection of what happened.
Wait, what are we talking about?
We're talking about two things. We're talking about 42, Nicole Brown Simpson blood pool results.
Yes.
And
Yeah, but Bobby,
we're talking about
what do you call
the
EDTA
request
in
for
Australia?
the PCR testing results of any of the investigating officer.
What do
with
they call
regard to
it?
the 4 allele on the steering wheel.
Could I ask that Mr. Harmon address the court on that matter because he handled it? I didn't.
Good afternoon, Mr. Harmon.
Starting with the request, in what seemed like a lifetime ago, we had a lot of requests from the defense. Some of them we acquiesced to initially because we had the material and it was readily available.
Well, let's cut to the chase.
Sure.
What's the state of the record?
The state of the record is, many months ago, they requested a broad request, all laboratory personnel, and a vague request for police personnel. We eventually provided all the PCR typing results for all the police personnel that we had, and then that were produced as this trial slowly progressed. And we told them that we didn't have them for police officers, and it is my recollection that that was the end of that, and that there was never a formal request made of you to resolve the impasse.
Problem is, this is reference to items not in the record. That's my concern.
Excuse me, Your Honor?
This is something that is not in the record before the jury, though.
Your Honor, may I?
Hold on, I'm not finished talking to Mr. Harmon. All right, that has not been a subject of question and answers before the jury, is that correct? My recollection is
That
that it
the
has
police
not.
officers were not typed?
Yes,
That's correct, Your Honor.
all right, thank you.
Mr. Harmon, listen carefully to his answer, because his answer accords with your recollection and my recollection. It wasn't a vague request. We requested the typings.
Counsel, the point is it in the record before the jury?
Yes,
The
no,
answer
no,
is
no,
no.
no, no,
Wait, no, counsel, that's the issue. If it's not in the record before the jury, then it's not something that's appropriate to have argument made of. Do you agree?
I agree with that, and
All right.
I have a further point, if you may just hear me. And that point is this, because you must instruct the jury to the contrary. As Mr. Harmon is indicating, and as the court recalls, we did make such a request for the typings of the police officers, and they chose not to do them. Mr. Harmon can say now they weren't available, so we did produce them, but the record and the truth is, we made the request, and they did not provide it. What Ms. Clark just told the jury is, if requests
I
for
know.
samples were made,
Counsel.
they would have been honored. That's
Counsel.
untrue, and they should be so instructed. A request was made, and it was not honored. Those are the facts. That's what the jury should be instructed. She had no right to say it in the first place, and what she said wasn't true, and that should be corrected.
Thank you.
Your Honor, can I just comment on that?
No, you don't need to comment on that. You know, it's obvious to me we're not going to finish this today, isn't it? So now what's going to happen is Ms. Clark's going to get a second wind over the weekend.
Why won't we be able to finish today?
You're going to finish in 90 minutes?
Yes.
Okay.
Especially if we don't have 90 minutes of argument in between. I'll be done. I will be done, Your Honor.
All right.
Now, I had no knowledge of what, it was my understanding from Mr. Harmon that the request was made. Mr. Harmon said, give me a list of the officers. They never came back to him, and that was the state of the record. And
State of the record is this: no typing results, PCR typing results, were made available to the defense by the prosecution during the course of the case. That's the state of the record. That is not
corrected.
before the jury, and you need to correct that.
Okay.
Request was made for it. That's the important point. She said a
All right.
request would have been honored, a request was made, and it wasn't honored.
You know what the problem is,
Wait.
Your Honor? It makes it sound as though there was a refusal, and that's not the truth.
What I'm asking you to say, correct your argument that no results, no PCR results of any of the investigating officers were provided to the defense. Need to correct that, period. All right?
Your Honor, what about the request? She said request.
Counsel, no.
Well, that's the truth. We made a request, and they didn't provide them. She said requests
Sit
would
down.
have been
I've
honored.
heard enough. We're going to conclude this.
Unfair.
Spicy.
Deputy Smith. Counsel on both sides, wide latitude in argument here. Thank you. Thank you. And I'm sure we'll have a chance to talk about it some other time. Gentlemen, please be seated. All right, let the record reflect that we've been rejoined by all the members of our jury panel. And Ms. Clark, you may conclude your summation.
Thank you, Your Honor. Almost done. Okay, let me correct one thing. With respect to on the steering wheel, the 4 allele, I'm informed by Mr. Harmon that we have not provided PCR results on the investigating officers. I would also remind you, ladies and gentlemen, that I think even Dr. Gerdes conceded that the 4 allele that was found on the steering wheel of the Bronco could have come from anyone driving the car. And as you know, there was testimony concerning other people driving the car. I think it was a housekeeper or something. Gigi also drives the car. So I was going to tell you about the border and the imprint on the carpet. Okay. And I want to show you this. First of all, let me show you Mark Furman's shoe, the one that was excluded, that he wore that night when he was at Bundy. It was excluded as having been a Bruno Mali by Mr. Boziak. And here's the bottom of his shoe.
What exhibit is this, counsel? Is this from the large board?
It's from 396, Your Honor.
Thank you.
Okay. You can see I think you can see pretty well. There's no squiggles on the heel. That's the important thing. Now, I'm going to ask for Mr. Goldberg to help me out here because he knows this better. There was an overlay made of the way it's a transparency with the way the Bruno Mali Silga sole looks. You can overlay that on this actual carpet stain and see how it lines up. Mr. Boziak, I would caution you, said that when somebody puts their foot on a carpet, again, this is common sense, you'll move it, you may twist it a little bit, so it's a little fuzzy, but you'll be able to see it. And I'm going to direct your attention, sorry about that, first of all, to this line here that is the border, and then the squiggles in here. And I'm going to have Mr. Goldberg line up the transparency so you can see what we're talking about. The red arrows that are on here, can you see them from where you are? They're little, okay. Agent Boziak was the one that marked these features to show what he thought was consistent with the Bruno Mali design.
Yeah, for the record, I just have equals 39DE.
Thank you.
Can everybody see? Can y'all see? Okay. Thank you, Your Honor. Now, what's key and fundamental to your belief that anyone other than the defendant could have put this bloody shoe print in the Bronco, and you recall that the testimony was that the typing came back to Nicole. That was her blood. What's key to your belief that it was not his shoe that put it there is the defense contention that he, in fact, was down in the crime scene pointing to the evidence at Bundy and stepped in her pool of blood before he went to Rockingham. Because if you rely on the state of the record, which states that he did not step down into that area until after he went to Rockingham, he didn't have opportunity to get her blood on his shoes. So the defense contention is that he actually took that photograph before he went to Rockingham, and that's how he got her blood on his shoes, and that's how the blood got on the carpet of the defendant's Bronco. However, the testimony elicited early in this trial is completely opposite. Completely opposite, and it's the testimony of an officer whose honesty was praised by defense counsel earlier in argument, Officer Risky. And he testified concerning that photograph as follows. At page 14-115, question. And by the time you came around to the front, was it starting to get light? Answer, no, it was. Question, still dark? Answer, still dark. Question, what did you do out front? Answer, like I said, maintain security of the crime scene. Question, at some point, a photographer arrived? Question, did you have contact with the photographer in the front of the location? Answer, yes, I did. Question, and was it daylight by then? Answer, I had talked to him earlier, but he hadn't taken any pictures of the front while I was there. Then he came, it was just starting to get daylight, and he came and he took a couple pictures. Question, now was this the same photographer you had contacted earlier at the rear of the location, the rear alley? Answer, yes, it was. Question, when he came to the front of the location and it was lighter, did you point anything out to him? Answer, no, I didn't. Question, did you see him taking pictures in that front area? Answer, I saw Detective Furman. He was showing him the glove, and he took a picture of the glove. Answer, question, okay, he was pointing to it. Answer, I believe he lifted up the leaves and the plant so he could see it better, and he took a picture. Question, And now I'm pointing to it. It's People's 55. You ready? Speed, please, Your Honor. We should mark it as People's 55, and then question. Do you recognize the person in that photograph, sir? Answer, yes, I do. Question, who is that? Answer, it's Detective Furman and the victim. Question, and what's he pointing to? Answer, he's pointing to the glove. Question, the glove and the cap? Answer, the cap. Question, the ones that you saw when you arrived shortly after midnight? Answer, that's correct. Page 14, 118.
Josh,
Question, now
I'm
what
glad
time
you
was it
didn't
that you
miss
were
the
relieved from
last
this crime
episode.
scene? Answer, 7:15. Question, at 7:15? Answer, that's correct. And in relationship to that time that you left the crime scene, when did Detective Furman appear and point out things to the photographer? Answer, I would say within 40 minutes, I'm not really sure, within an hour. Question, so it was shortly before you left the crime scene completely? Correct, right. So 40 minutes to an hour before Mr. Officer Risky left the scene, and he left at 7:15, is when that photograph was taken. He was there, and he saw it happen. And that was after Mark Furman came back from Rockingham. Mystery solved. And that shoe print belongs to the defendant. What you've seen, ladies and gentlemen, is a very elaborate effort to make you disbelieve a great wealth of evidence. And what you've heard is basically a conspiracy that extends from Officer Risky to Commander Bushy. Do you realize how many people would have had to have gotten involved in a conspiracy within an hour? Can you imagine how this could happen? Detective Van Adder and Detective Lang never even knew Mark Furman until they met him that night at Bundy. And yet the allegation by the defense is that they got together that night, meeting for the very first time, and everybody's covering up and conspiring all of a sudden. Impossible. Not only that, but there are other people involved as well, people we don't even know who they are, according to the defense, who are willing to get involved in this. Do you realize how many people have to be involved? I mean, it boggles the mind. We don't even know who they're talking about. But that's the contortion you have to go through to believe in this conspiracy theory. That's the contortion you have to go through to step away from the very obvious truth that you can see when you look straight on and clear-eyed at this evidence. If you look at it straight on, you can see the truth. It's very clear, and it's very obvious. Mr. Simpson committed these murders, ladies and gentlemen. We don't like it, and it's hard, but it's true. Now, I have one more exhibit I'd like to show you. And this exhibit is entitled Unrefuted Evidence. And I think that this will bring home to you the power of the evidence in this case. And the reason that there are two men now helping is because it's a magnetic board and it weighs about a ton.
All right, Ms. Clark.
Thank you, Your Honor. This is the unrefuted evidence. This is evidence which has not been contested by any contradictory evidence. That's all that's on this board. Okay? First of all, it goes...
Excuse me, sorry. Forgive me for interrupting. Any remains on this board?
No, Your Honor.
All right,
No,
please.
wait, maybe I have to wait. Yes. But we're not going to get to it just yet. Shall I tell you when? Or do you want to just go ahead and cut?
Tell Mr. Bancroft when.
Okay. First of all, opportunity. Opportunity deals with the time. As we've already established, between 9:36 and 10:53, the defendant's whereabouts are unaccounted for. No dispute about that. Nobody's contradicting that. Cato Kalin saw the defendant wearing a dark sweatsuit at 9:36. No contradictory testimony about that. Charles Cale did not see the Bronco on Rockingham when he walked his dog between 9:30 and 9:45. No witness came forward to dispute that either. The defendant tried to call Paula Barbieri on his cell phone from the Bronco at 10:02, 10:03. There is no contradictory testimony as to that fact. Alan Park did not see the Bronco on Rockingham at 10:22 or 10:30. No witness came forward to contradict his testimony. Alan Park buzzed the intercom at Rockingham at 10:40, at 10:43, and at 10:49. There was no answer. No testimony contradicts that. A white, very light-colored Bronco-type vehicle observed at Bundy and Dorothy after the murders occurred. That was the testimony of Mr. Hydestra. Testimony that was not contradicted.
Overruled, counsel. Counsel, that objection has been made. It's for the record. Thank you.
Cato Kalin heard the 3 thumps on his wall at 10:51 or 10:52. That testimony is uncontradicted. Let me make one further point about that. An argument has been made to you, ladies and gentlemen, that somehow those thumps were a signal. That is not what Cato said. That is not what he said. Nor was he questioned as to whether or not the thumps he demonstrated for you were that fast or was it slower. He was indicating to you the force, why his walls shook. Now, how could an earthquake sound like this? Okay? He said an earthquake. He said a prowler. Those were the things that he said. He did not say signal. It didn't sound like that to him. That's what he said. Earthquake, prowler. Those were his words, uncontradicted. Allen Park saw the person in dark clothes, 6 foot 200 pounds, walk across the driveway at 10:54, walking into the house. Testimony that is uncontradicted. 2 minutes after the thumps heard by Cato, uncontradicted testimony. And at 10:55, when Allen Park got out of his limo to go and buzz the defendant finally answered. That testimony, ladies and gentlemen, is uncontradicted. What that testimony proves is not only that the defendant was not home, but it proves he was not sleeping, and it proves that he lied about it to create the impression, to create an alibi for himself. You don't need to do that unless you've been doing something you need to have an alibi for, unless you've been doing something that you need to hide. Shoe prints at Bundy were from a size 12 Bruno Magli shoe. There is no contradiction for that testimony. The defendant wears a size 12 shoe. That testimony is uncontradicted. The bloody shoe impression on the Bronco carpet is consistent with the Bruno Magli shoe. That testimony is uncontradicted. That's the one we just showed you. The left glove at Bundy and the right glove at Rockingham are Eris-like gloves, size extra large, uncontradicted. Nicole Brown bought 2 pair of Eris-like gloves at Bloomingdale's in New York on December 18th, 1990. Testimony that is uncontradicted.
Overruled, counsel.
The defendant wore black and brown Eris-like gloves between December 18th, 1990 and June the 12th, 1994. Let me make one further point about that. If the gloves you saw him in these photographs that we showed to you, ladies and gentlemen, were not the ones purchased for him by Nicole Brown, why is it we have no photographs dating before the day she purchased those 2 pair of gloves?
Overruled. It's a fair inference from the evidence, counsel.
Which only shows, ladies and gentlemen, and highlights one further point for you. Where are they? If they are not the gloves you have here in court, where are they? They are here.
Yo, that's not fair. That is just not fair. Because trust me on this. I cannot keep a pair of gloves for years. I can keep a glove for years, but never 2. No, I gotta buy gloves every winter. I don't have gloves right now. So that she's misleading them. Where are they? There, wherever. Gloves running high to with the socks. No. But Marsha's doing really good right now. Really, really good. Putting this all together like that.
Overruled, counsel. Counsel.
The killer dropped blood to the left of the shoe prints at Bundy. That's testimony that is uncontradicted. The defendant had fresh cuts on his left hand during the week of June the 13th, 1994. Uncontradicted. A blood drop on the Bundy trail was typed the same as the defendant's, and this is the conventional serology I was telling you. This is the PGM typing that they did, not the DNA. This is uncontradicted. No one contradicts the accuracy or the integrity of that. No one claims that that's the product of contamination.
Overruled, counsel.
Blood transfers were visible in the defendant's Bronco. Officer Don Thompson, who was at Rockingham that morning, said he saw blood in the Bronco. Blood drops are on the street in the driveway, 360 Rockingham, uncontradicted. Blood drops were found in the foyer and in the master bathroom at Rockingham. Testimony that's uncontradicted. It's also uncontradicted that it's his blood. Yes, now, Your Honor, thank you.
All right.
Okay. Fibers consistent with the carpet from the Bronco found on Rockingham glove? Uncontradicted. Blue-black cotton fiber found on Ronald Goldman's shirt, the defendant's socks, and the Rockingham glove? Uncontradicted. Fiber consistent with the carpet from the Bronco found on the dark knit cap at Bundy? Uncontradicted. Hairs consistent with the defendant found on the dark knit cap at Bundy? Uncontradicted. Hairs consistent with the defendant found on Ron Goldman's shirt? Uncontradicted. And in this, I refer to head hair as well as limb hairs.
Oh,
Motive? You know. Full circle. Spousal abuse, domestic violence against Nicole Brown. Unrefuted. You can see, ladies and gentlemen, this is just what hasn't been contested. Now you add to that the fact of all of the evidence that they've tried to claim was contaminated or planted. I've shown you how it wasn't. Add all of that to this. It is truly overwhelming. If you would like to take notes on this, I can leave it up for a little while. It won't go back with you to the jury room because it's only for argument. All right.
excuse me, counsel, would you just approach real quick? All right, thank you, counsel. Proceed.
Thank you. I'd like to conclude my remarks to you today, ladies and gentlemen. I wanted to remind you, because we've come full circle, I've been with you such a long time. It's been so long since we've actually had a chance to both talk, and I look forward to the time that we can, again. I wanted to remind you back to the time of jury selection when we first asked questions of you as a group in order to select 12 of you to sit as jurors, and that was on, I think, November 2nd, 1994. You were all together here, and we were actually able to both talk and exchange. I think it was even before the alternate jurors were selected. And we asked some of you as individuals what you would expect of us as public prosecutors if we were assigned to prosecute a case where, heaven forbid, a loved one of yours had been murdered, a son, a sister, a father, a brother. And imagine that it's you sitting in the audience where the victim's families sit today. What would you expect of us? What would you want? Your answers were that you expected us to be fair, to be vigorous in our prosecution of the case, to be ethical. We've done everything in our power to be all of those things, ladies and gentlemen, everything. And if you recall, we as representatives of the community expected of you, and we talked about what we wanted, what we would ask of you. And if you remember, we expected you to use your common sense, to be open-minded, to be reasonable, and to be fair, and to have the moral courage to be just. And if you will think back to that time of jury selection when all of you were first together, you'll remember that we talked about the United States Supreme Court building in Washington, D.C. It's been so long, I wonder if you remember that. The highest court in the land. And we asked if you knew what was inscribed on the facade of the Supreme Court building up above the steps, up above the pillars. If you think back, we told you what was written above those marble pillars. Equal justice under the law. We talked about what that meant, equal justice under the law. You may recall that means the law is to be applied equally to all persons in this country, regardless of whether one is rich or poor, or race or creed or color, famous or otherwise. Not even the President of the United States is above the law. You all agreed with that. We asked you if you had the courage to be just. To a person, each of you said yes. Some individually, some responded as a group. And we asked you, you may recall, what equal justice under the law meant to you. And you replied, that is the way it should definitely be. And that's right, that is the way it should definitely be. But you see, equal justice under the law is an ideal, it's an abstract principle. And it takes you to make this principle a reality. Only you can make this ideal real. I think that with all you've already gone through, you've shown
He
yourselves to
did
be
that
people of
before
remarkable
closing
integrity,
statement
strength,
started.
courage,
He gave instructions.
and patience. People who will face the hard questions. And this is one of them. I think it's been hard for all of us to be here and to listen to all of the evidence. In this case, evidence that proves Mr. Simpson is guilty, because none of us wanted to believe it. We all wanted to believe that our image of him was right. And we all know that we never knew him exactly, but we kind of felt like we did. And it's really kind of hard to have to believe that the man we saw in the movies and the commercials could do this. But he did. And the fact that he did doesn't mean he wasn't a great football player. It doesn't mean he never did a good thing in his life. Nothing takes that away. That's still here. It'll always be here. But so will the fact that he committed these murders. And even though it's a hard thing, still it cannot mean that you let a guilty person go free. That someone who commits murder is not held accountable for it. He had strength and he had weaknesses. And it's his weakness that brought us here today. And it's his weakness, that's why we're here, and Ron and Nicole are not. And the defense would say no motive. No motive. It's one of the oldest motives ever known, ladies and gentlemen. Anger, fear of abandonment, jealousy, loss of control of Nicole and of himself. Children were there. 1990, she made a safe deposit box, put photographs of her beaten face and her haunted look in a safe deposit box along with a will. She was only 30 years old. How many 30-year-olds you know do that? A will, a safe deposit box? It's like writing, in the event of my death. She knew. He's going to kill me. 1993, the 911 tape. Children were there. He was screaming, she was crying, and she was frightened. I think the thing that perhaps was so chilling about her voice is that sound of resignation. There was a resignation to it, inevitability. She knew she was going to die. And Ron, he speaks to you, in struggling so valiantly. He forced his murderer to leave the evidence behind that you might not ordinarily have found. And they both are telling you who did it with their hair, their clothes, their bodies, their blood. They tell you he did it. He did it. Mr. Simpson, Orenthal Simpson. He did it. They told you in the only way they can. Will you hear them? Or will you ignore their plea for justice? Or as Nicole said to Detective Edwards, you never do anything about him. Will you? I want to play something for you, ladies and gentlemen. It puts it all together. Let me explain what this is. Thank you. This is a compilation of the 1989 tape, 911 call, the 1993 911 call, photographs from 1989 beating, and the photographs from her safe deposit box, and the photographs from Rockingham and Bundy.
Hello?
I don't have to say anything else. Ladies and gentlemen, on behalf of the people of the state of California, because we have proven beyond a reasonable doubt, far beyond a reasonable doubt, that the defendant committed these murders, we ask you to find the defendant guilty of murder in the first degree of Ronald Goldman and Nicole Brown. Thank you very much.
All right, thank you, counsel. Let me see counsel to sidebar with the court reporter, please.
Guys. Oh, there's a huge spike right here. I don't know what's happening.
All right, ladies and gentlemen, thank you for your patience. I have just a few final instructions that I need to give to you before you start your deliberations on this matter. Ladies and gentlemen, I have not intended by anything that I have said or done, or by any questions that I may have asked, or by any of the rulings that I have made in your presence, to intimate or suggest what you should find to be the facts, or that I believe or disbelieve any of the witnesses. If anything that I have done during the course of this trial or said has seemed to so indicate to you, you will disregard it and form your own conclusion. The instructions which I have given to you will be made available in written form for your deliberations. They must not be defaced or written upon in any way. You will find that the instructions may be typed, printed, or handwritten. Portions may have been added or deleted. You must disregard any deleted part of an instruction and not speculate as to what it was or as to the reason for its deletion. You are not to be concerned with the reasons for any modifications. Every part of the text of an instruction, whether it is typed, printed, or handwritten, is of equal importance. You are to be governed only by the instruction in its final wording. The people and the defendant are entitled to the individual opinion of each juror. Each of you must consider the evidence for the purpose of reaching a verdict if you can do so. Each of you must decide the case for yourself, but should do so only after discussing the evidence and the instructions with the other jurors. Do not hesitate to change an opinion if you are convinced it is wrong. However, do not decide any question in a particular way because a majority of the jurors, or any of them, favor such a decision. Do not decide any issue in this case by chance, such as the drawing of lots or by any other chance determination.
What I'll do, sir, is use these
The
documents
attitude and conduct of jurors at all times are very important. It is rarely helpful for a juror at the beginning of deliberations to express an emphatic opinion on the case or to announce a determination to stand for a certain verdict. When one does that at the outset, a sense of pride may be aroused, and one may hesitate to change a position even if it is shown to be wrong. Remember that you are not partisans or advocates in this matter. You are the impartial judges of the facts. In your deliberations, do not discuss or consider the subject of penalty or punishment. That subject must not in any way affect your verdict. Do not disclose to anyone outside the jury, not even to me or to any member of my staff, either orally or in writing, how you may be divided numerically in your balloting as to any issue unless I specifically direct otherwise. You have been given notebooks and pencils. You are to leave them in your seat in the jury room when you leave each day and at each recess. You will be able to take them into the jury room for your deliberations. You are reminded that notes are only an aid to memory and should not take precedence over independent recollection. A juror who does not take notes should rely upon his or her independent recollection of the evidence and not be influenced by the fact that other jurors do take notes. Notes are for the note-taker's own personal use in refreshing his or her recollection of the evidence. Finally, should any discrepancy exist between a juror's recollection of the evidence and his or her notes, he or she may request that the court reporter read back the relevant proceedings, and the trial transcript must prevail over any notes. In this case, there are 3 possible verdicts as to each count. These various possible verdicts are set forth in the forms of verdict which you will receive. Only one of the possible verdicts may be returned by you as to any particular count. If you all have agreed upon one verdict as to a particular count, the corresponding form is the only verdict form to be signed as to that count. The other forms are to be left unsigned. During the periods of recess, you must not discuss with anyone any subject connected with this trial, and you must not deliberate further upon the case until all 12 of you are together and reassembled in the jury room. Once the clerk or the bailiff has been notified that the jury is reassembled, you may continue your deliberations. During the course of their arguments, counsels for both sides argued that, quote, the world is watching, unquote. You are reminded that you must not be influenced by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Both the prosecution and the defendant have a right to expect that you will conscientiously consider and weigh all the evidence, apply the law as I have instructed you, and reach a just verdict regardless of the consequences. You shall now retire and select one of your number to act as foreperson. He or she will preside over your deliberations. In order to reach verdicts, all 12 jurors must agree as to the decision and as to any finding you have been instructed to include in your verdict. As soon as all of you have agreed upon a verdict, so that when polled each may state truthfully that the verdicts express his or her vote, have them dated and signed by your foreperson and then return with them to this courtroom. You are to return to the clerk any unsigned verdict forms. Mrs. Robertson, are you prepared to swear the bailiff? All right, Sergeant Smith.
Mrs. Robinson looks so pretty today.
All right, ladies and gentlemen, I'm going to ask that you step into the jury room to proceed with your election of a foreperson. As soon as you have done that, would you notify the bailiffs by pressing on our buzzer 3 times here that you've reached a determination as to the foreperson, and then I'll bring you out for the closing admonitions, and then we'll conclude the session for the day. In fact, I think what I will do is give them the closing admonition at this time. Ladies and gentlemen, I've indicated to you, you were not to discuss the case while you are away from the jury room. Your jury deliberations may take place only while all 12 of you are assembled in the jury room. In other words, when you go back to the hotel, when we conclude for the day, and during the course of any recesses, you may not discuss amongst yourselves the facts and circumstances of the case. You may not conduct any deliberations while you're at the hotel or anywhere in between. All right? And I'll ask the 12 jurors to step back into the jury room at this time, and we'll have the bailiffs take charge of the 2 alternates. All right, I need to see counsel. Excuse me. Any other jury rooms presently available for the 2 alternates? Back. I'll have to check 1 or 2 things. All right. One matter of sequestration I wanted to ask counsel about. My research attorneys advised me that there is case law that alternate jurors are to be kept separate from sequestered jurors during the part of their deliberations, which includes at the hotel, according to the case law that I've read. Now, they've been admonished not to conduct any deliberations while they are away from the jury room here in the courthouse, and I'll be issuing shortly a schedule of jury deliberations. What are your thoughts as far as keeping the 2 alternates separate?
With regard to that, I think you admonished them. The defense has absolutely no objection to the alternates being able to be with the other jurors during the time they're at the hotels. They're not going to deliberate. They've been together all this time, and I think that's appropriate. We have no objection to that, Your Honor. I think it's appropriate. We so stipulate.
I gotta see Michael's side for him. You to have 2 of them separate from everybody else and all their friends. It's hard enough where they're living. I can't object to them being together after all they've been through. So,
All right.
Stipulation is required. We stipulate.
yeah.
All right. That seems the humane thing to do.
Okay, I know why. I know why. We're about to hit a great big jump. I know why. I know why. They're about to complain about Juror 7 in court. They're all going to complain about Juror 7. What do you think? You think that's why the big jump is?
It'll be bad enough keeping them separate in another room during this time in any event. All right, counsel, I'm going to direct counsel to be available within 1 hour's phone call, within 1 hour of receiving a call from Mrs. Robertson, the clerk, to be available with regards to questions and jury readback. And I understand that both sides wish to be present during any readback, and the defendant wishes to be present. Is that correct?
Yes, Your Honor. That is, Mr. Carl Douglas will be our designee for all readbacks. Mr. Simpson would like to be present for all such readbacks, if the court pleases. There's one other request I have, Your Honor, with regard to verdict when you get to that point. Should I do that now?
All right. Ms. Clark, any problem with designating one individual on your team to be the person to respond within 1 hour to Mrs. Robertson's call?
Yes, I mean, no, is it all right with the court if we can alternate? I don't want to have any one person always be up, but if
Just
you
as
can
long
notify...
as long as I have somebody here in 1 hour. All right. Mr. Carpenter, you had a question regarding the
Yes, the
verdicts.
court, as the court knows, this is a part of the case where one does not know how long it will take, and this has been a very long trial, and because counsel have been tied up in this matter for some time, maybe they have a verdict already, and we can go home. Maybe that's maybe that's it. Maybe the question will be moot.
It's a good sign that they can agree that quickly on a 4-person, but since
four-person,
they...
yeah,
Since,
that is a good
can we have
sign.
quiet, please?
The point I was going to indicate to the court was whether or not, and it may not be necessary, whether or not we can have, the court has indicated that
We
they'll be
are
deliberating, I
live.
believe, on some
This
weekends,
is live.
and that could we have a 24-hour window from the time that the court gets the verdict to the time that
I
all
do
counsel want to be
deceive.
present, if it's all possible.
My concern, counsel, is that we have a sequestered jury, and to keep them any longer than is necessary after they deliver a verdict would be very difficult.
I understand that.
I'm going to ask counsel to be available within 4 hours of being notified.
The court, because someone's going to be out of time, the court consider that, making that 6 hours possibly.
Let's say 4 hours, and let's see where you are when it happens. Let's not create on any windows that are too wide, keeping in mind that once this jury reaches a verdict, I suspect they'll want to go home.
I would think so, but we'll see. All right.
All right. That'll give all parties the opportune time, enough time to get their the interested parties together and to assemble here at the courthouse. All right, Ms. Clark, Mr. Carpenter, is there anything else we need to take up?
Juror 7 never saw that.
The verdict is at 4, it's 5 o'clock in the afternoon. I presume that the court would then go over more than likely to the next day, or on Saturday.
I'll issue a deliberation schedule and an anticipated schedule of returning verdicts while this jury deliberates. I am contemplating, as you know, the jury asked for permission to deliberate on Saturdays, as they're willing. They told me that they were in their questionnaires that since they're sequestered, they might as well work on Saturday. If a verdict is returned on a Saturday, it will probably be held until Monday, simply because of the logistical problems of opening the courthouse over the weekend to take a verdict. All right, so you should anticipate that. Anything else? All right, counsel, thank you very much. We'll be in recess. All right, I'll see counsel in chambers without the...
We made it. This is it. This is the last video. It's 14 minutes long, and we are playing it at 1.25 speed, so it'll be a little quicker than that. This is it. We started this in December of 2024, and we are about to hit the end, guys. We are 10 minutes away from the end. Ish. Oh, man. This is crazy. Here we go. Thank you so much for joining me for the OJ trial. The whole OJ trial. Thank you. I really appreciate it. They deliberated for 3 hours and 35 minutes.
All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Courtroom, Mr. Kardashian, Mr. Bailey, Mr. Blazer. People represented by Ms. Clark, Mr. Darden, and Mr. Hodgman. The jury is not present. Good morning, counsel. All right, the record should reflect that earlier this morning at 9 o'clock, the court met informally with counsel here in the courtroom, because there are too many lawyers to go into chambers this morning, for the purposes of discussing notifications to the jurors regarding their rights of privacy and the interest of the news media to interview them or speak to them following the delivery of the verdict in court here today. The court distributed to the parties copies of the questionnaire that has been distributed to the jurors, and also the notice to them regarding confidentiality under 237 of the Code of Civil Procedure. And those two questionnaires have been returned by the jurors. They have uniformly indicated their desire that their private information remain confidential. They have also indicated to the court unanimously a desire not to speak to the attorneys, including after the conclusion of the trial, and not to speak with the news media either. All right, counsel, is there anything else we need to take up before I invite the jurors to join us? All right, Deputy Trial, let's have the jurors, please.
All right, I'm going to pause this real quick while they're messing around. I'm going to post a link in chat. This is what I've decided, guys. So, I've done some trials on Court 5s. But the three biggest ones I've did was Michael McDonald, OJ Simpson, and George Kelly. All three of them failed miserably on this channel and took all the numbers of the channel way down. And it's going to take me a while to fix it after this OJ trial, because it's been bad, seriously wretched bad numbers for well over a year. So I just posted a link in chat. That's where we're going to do any new trials. Long trials, they're going to be done on that channel. It's not monetized or anything yet. It's specifically for long trials. So we're going to keep Court Vibes, just, the live streams, the regular live streams. Court Disorder is the videos. Court Access is going to be long, beautiful trials. And I think that's a good balance, right? That way I can move forward with Court Vibes, and we can still do trials together. So I'm ready to do any trial over there. It doesn't matter. I'm not monetized over there. I can do whatever I want. But we have more options now now that we do that. I think that's great. I think that's a good middle ground, right? We both get what we want. So anyway, I'm ready for ideas of whatever you want me to put over there. I did reach out to Florida, to a different department in Florida, trying to get the Ted Bundy trials. The first department, I reached out on January 16th or 15th, and I didn't hear anything from them. So on January 29th, I reached out again. I said, yo, answer me. They did not answer. So I took that email chain and I emailed somebody else. And I said, I'm not getting any answer. So working on that, working on Indiana, Bobby, working on them, getting them to give me that trial. But yeah. Okay, back to work, guys, back to work.
All right, Madam Foreperson, would you please open the envelope and check the condition of the verdict forms?
You are not the father.
All right, Madam Foreperson, you've had the opportunity to review the verdict forms.
Yes.
Are they the same forms that you signed, and are they in order?
Yes, they are.
All right, would you hand those, please, to Deputy Trevor? And you have signed and dated those verdict forms indicating the jury's verdict?
I don't care about luck. I enjoy it. I can do controversial over on that channel, no problem. Not monetized.
All right, ladies and gentlemen and of the jury, I'm going to ask that you carefully listen to the verdicts as they are being read by the clerk, Mrs. Robertson.
Kardashians
As
in the
after
front
the
row.
verdicts have been read, you will be asked if these are your verdicts. And I would caution the audience during the course of the reading of these verdicts to remain calm, and that if there is any disruption during the reading of the verdicts, the bailiffs will have the obligation to remove any persons disrupting these proceedings. All right, Mrs. Robertson.
Ladies and gentlemen of the jury, is this your verdict? So say you one, so say you all.
All right, counsel, Mr. Simpson, would you be seated, please? Let's have it quiet in the courtroom, please. All right, Mrs. Robertson, would you please poll the jurors?
Juror number 1, as to count 1, is this your verdict? Juror number 2, as to count 1, is this your verdict? Juror number 3, as to count 1, is this your verdict? Juror number 4, as to count 1, is this your verdict?
Yes.
Juror number 5, as to count 1, is this your verdict? Yes. Juror number 6, as to count 1, is this your verdict? Yes. Juror number 7, as to count 1, is this your verdict? Juror number 8, as to count 1, is this your verdict? Juror number 9, as to count 1, is this your verdict? Juror number 10, as to count 1, is this your verdict? Juror number 11, as to count 1, is this your verdict? Juror number 12, as to count 1, is this your verdict? Okay, count 2. Juror number 1, as to count 2, is this your verdict? Yes. Juror number 2, as to count 2, is this your verdict? Juror number 3, as to count 2, is this your verdict? Juror number 4, as to count 2, is this your verdict? Yes. Juror number 5, as to count 2, is this your verdict? Yes. Juror number 6, as to count 2, is this your verdict? Yes. Juror number 7, as to count 2, is this your verdict? Yes. Juror number 8, as to count 2, is this your verdict? Yes. Juror number 9, as to count 2, is this your verdict? Yes. Juror number 10, as to count 2, is this your verdict? Juror number 11, as to count 2, is this your verdict? Juror number 12, as to count 2, is this your verdict?
All right, the clerk is directed to record the verdicts as read. The parties agree to waive reading of the verdicts as recorded. Mr. Cochran, do you waive reading of the verdicts as recorded? Yes, we do. Ms. Clark, thank you. All right, ladies and gentlemen, I want to at this time take this opportunity to publicly thank you for the service that you've given to us The burdens that we've placed upon you were enormous, and words can't begin to express the debt that we owe to you for the time, patience, and exertion that you've given to us during the course of this case. I will have an opportunity to meet with you privately later, and I'll give you my private comments when we have a chance to meet. I want to caution you at this time that there is, as you know, intense media interest in this case. The news media will probably seek you out at your home or at your place of business. And I would implore that the news media act responsibly to avoid harassing you or identifying you without your consent or otherwise causing you concern. Whether you wish to cooperate with the news media is, of course, entirely up to you. However, I must warn you to expect the worst as far as that is concerned. We want to, I know I share with you in expressing our thanks to the bailiffs from the Sheriff's Department, to our court reporters, Ms. Moxham and Ms. Olson, to the research attorney, John Byrne, who's assisted us, our Pepperdine law clerks, Mr. Golub and Ms. Carswell, our media liaison, Jerry Ann Hazlett and her staff, and of course the jury commissioner, Gloria Gomez, and her staff. All right, counsel, is there anything we need to take up before we excuse the jurors, Mr. Cochran?
I don't hear anything either. Your volume is fine.
All right, ladies and gentlemen of the jury, I am now going to excuse you from further service on this case. As you know, this does absolve you from your vows of silence. You may take with you your juror notebooks as you have requested, and we'll be chatting with you shortly. All right, thank you very much, and I'll see you all later. All right.
I'll see you all later. No, you won't. They're going home. They're running out the door, and they're going home. I just can't believe Richard's not here. It just hurt my heart.
Everybody have a seat, please. All right, Ms. Clark, Mr. Cochran, anything else we need to take up? Ms. Clark? All right, the defendant, having been acquitted of both charges, he is ordered transported to an appropriate sheriff's facility and released forthwith. All right, we'll stand in recess.
It's not over yet. There's a spike. Oh, wait. No, we passed it. It's over. The spike was them walking out. It's over. It's done. The whole trial is done. Holy crap, guys. We finished the OJ Simpson trial. I feel like we just read Bleak House, which is an excellent book to read. Just fabulous. Except for the very end. But still great. But it's like, we read War and Peace. We just finished it. We just closed War and Peace. It's over. We read it. We did it. Man. Thank you so much. Thank you so much for watching the OJ Simpson trial with me. I really appreciate it. I really do. I really enjoyed it. If I didn't enjoy it, I would have stopped this silliness 6 months ago. Ray Lewis. I don't want to get tackled. All right, guys. You guys have just gained 2 more hours of your days that you never had for the last year. How are you going to spend it? What are you going to do with those extra 2 hours? I hope you sleep. It is a badge of honor. Jude, thank you so much. I appreciate you. Thank you. All right. Time to watch a civil case. I don't know if there's any video. I think I looked for it a couple times. Can't find video of it. But guys, have a great whatever, you know? I don't know what to say now. Day, week, month, year. Anyway, look, I'll see you tomorrow morning at 4:30 for regular court vibes. I hope you guys have a great day. Thank you so much. Bye, guys.